Thank you very much for joining us today for the second part of our series on residency. Today, I'm very, very lucky to be joined by my colleague, Rebecca and Victoria, who will introduce themselves in a moment. Before we do that, though, just a reminder that this is part of a series we're doing. Our next event will be on the 23rd of September and will be a webinar about doing business in the UK. So if you're finding today's webinar interesting because you're coming to the UK, hopefully that doing business will be useful to you too. Also to let you know that there will be some, this will be recorded and you'll get a copy of this coming around over the next few days, along with some notes that you may find useful, and a bonus video which has been provided by one of my fellow tax partners here, Tom Adcock, who will be discussing one of the aspects that we're talking about today in a bit more detail, which is coming back to the UK. So watch out for that. Also, just to let you know that David will be sending around a poll a little later in relation to this webinar. And if you've got any questions, please pop them in the chat. And at the end, we'll come back to them. So without further ado, though, let me introduce the panel today. Rebecca.
So my name's Rebecca Amy, and I am the Payroll Director here at Gravita.
Victoria.
I'm Victoria Welsh. I'm Head of Immigration at Taylor Rose.
And I'm Michaela Lamb, one of the private client tax partners here at Gravita. So we're covering a lot of information today, but I think it would be useful that before we start to cover a couple of the key concepts. So I'm going to ask Rebecca to tell us a bit more about what a DPNI scheme is, because that's quite key in what we're talking about today.
Sure. So a DPNI scheme is a HMRC approved scheme that's designed so that UK tax residents working for non-UK employers can still pay their tax and national insurance across to HMRC. And then there is a DCNI scheme. So it's the same kind of scheme, but that's purely to pay your national insurance across. We'll go into a bit more detail on, yeah. Yeah.
So the way today is going to work is we're going to look at a number of scenarios and take you through the legal, the payrolling, and then the tax aspects involved in each of those scenarios of people coming to the UK. And most of these are kind of scenarios we come across relatively regularly. Yeah. So we're trying to put it all into context for you. The other important thing I think to remember, and I'm going to say this because you're going to say it anyway, but legal and tax residency are different, aren't they?
Very different.
Very different. So we will try and explain that as we go along. So Victoria, do you want to set out the first scenario for us then?
Thanks, Michaela. Yes. So a common inquiry that we get for immigration law is where there is an established overseas business. So we've selected just randomly from the travel sector, an established travel sector business operating in Malaysia. They want to expand into the UK market for various reasons. They've identified somebody in the UK who they want to work for them to get that going. They also want to transfer people from their overseas office into the UK to help with expansion and ensure consistency of the brand. They don't have a fixed period of time for that, so it's open-ended. And they don't currently have a UK company or presence.
Well, lots going on then.
Lots going on, but it's a very, very common scenario that we see.
Yeah. Do you want to go to the legal side of that first? How does that work?
So the first thing that we'd have to look at from the immigration perspective is understanding that person in the UK, do they have the right to work already? If they don't, what visa are they on? Does it allow them to do what they want the person to do? To be honest, most of the time they've come to me because the person needs a visa and they need to be sponsored because they need to have a skilled worker or some such visa like that. And that then flows that the company needs to obtain a sponsor license.
Is that easy to get?
Well, they have no company currently in this scenario. Okay. So that's going to be the first hurdle, is they're going to have to set up something registered with Companies House and then probably speak to people like yourselves. Yes. For a sponsor license, quite a lot of evidence is required for UK presence to demonstrate that the company is fully compliant with UK laws and regulations. So registration with HMRC for payroll, insurances, a fully regulated bank account is also required for a company just setting up. So that's with Bank of England as well as FCA registrations. That can be quite a big hurdle. Any regulatory requirements that are associated with that type of business also need to be registered. Something that we see quite a lot in these scenarios is the question of, could we use an employer of record? And I think it's really important to make the point that in the sponsorship context, that's not compliant right to work because it takes away the employment relationship from where the activities of the worker are actually going to be.
And we'll have a look at a bit more about employment record.
But I guess they're not physically their employer anymore, are they?
exactly.
Yeah.
Problematic. Okay. All right, so what about things like visas? Do we need to worry about things like that, or?
Well, once they've got the sponsor license in place, that's when they can start to issue the sponsorship for the worker. So early planning is really important here.
Right.
It can take, especially if they've got to go right from the very beginning, this can take months and months and months to get sorted. So the earlier they start to plan, the better.
Sensible, fantastic.
And all of this has to be in place before they can even make an offer of employment.
I mean, that's more, that's
It's
a good question. And I've seen it go both ways. I've seen some people make the offer. You do have to handle it very carefully because you are dealing with someone's visa with another employer. So I do suggest to think about all of the implications of that before going ahead.
Okay, so what about the difference between those who are coming here for quite a long time or people who are just kind of passing through? Is there a massive difference on that?
There can be. So the scenario where you've already got somebody in the UK is one way to think about it. But of course, if they are looking to send people over from their overseas offices, they could consider whether that would fall within the visitor rules.
Okay.
There are other intra-corporate routes that work as well as individual eligibility, which fall outside of the sponsorship regime, and which can be a little more flexible.
Okay, that may help then, hopefully.
It can do.
So lots of options. Okay, so from a payroll perspective then.
So from a payroll,
what happens?
Yeah, so from a payroll perspective, they are creating a presence, and that's the key word here, presence. They're creating a presence here in the UK, so they would need a normal UK PAYE scheme.
Okay.
So they would have to register with HMRC for the PAYE scheme, a workplace qualifying pension scheme. I think registration can take anything up to 12 weeks at the moment. It's
a long time, isn't it?
Yeah, just to add to all the other stuff they've got to do beforehand.
But they can pay them first, though.
Yes, absolutely. So you don't need to receive these references prior to running a payroll. You just can't submit.
Submit. So you just have to deduct the money, presumably.
Yeah, I mean, with payroll, what's the most important thing? Paying people.
People get paid.
Yeah. So you can absolutely do that. You just need to wait for these references to arrive. One thing I will mention is that the employee should probably think about if the employees that they're thinking of sending over, they would need to apply for UK national insurance numbers prior to arriving in the UK. Again, I think there's a bit of a delay on receiving them as well.
It's quite a tricky process getting a national insurance number because we can't help them with it.
Well, with some of the work routes, particularly the sponsorship routes, that is actually built into the process. So when they apply for a sponsored visa, the national insurance number application comes as part of it, and it's issued to them when the visa is issued.
That's
wow. Okay, I didn't actually know that.
Every day in school day.
Every day is a school day. So yeah, it would just be in this case, it would be a normal UK payroll. They are creating the presence here. They are required to do that.
And that is the employer who does that. Nothing to do with the employee.
Nothing to do with the employee. They will go on to PAYE and just be paid their net salary as normal UK payroll.
That makes sense. Okay. Well, so from a tax perspective, though, it's again for those who are already here. That's really easy because they're going to carry on paying tax on their worldwide income the way they do before. What's more interesting are the guys who are coming to the UK, and it will depend very much on their circumstances as to whether they end up paying UK taxes or not. Because if they become UK tax resident under the statutory residency test, for example, because they're here quite a long time, they're going to pay tax certainly on their UK sourced income, but they may qualify for something called the FIG regime, which is the foreign income and gains regime, if they're only here for a short period of time. So if they've never been in the UK before, or they haven't for the last 10 years, for the first 4 years that they are here, they'll only pay tax on their UK source income, so the employment income, rather than their worldwide. So if they've got investments, for example, back in Malaysia, and they suddenly become UK tax resident, they can use this regime to avoid that. If they don't qualify for the FIG regime, technically, if they're tax resident in the UK, they will pay tax on their worldwide income and gains. Now, there are some reliefs going through the double tax treaty if they end up being tax resident in both places, so we would need to consider where they're actually resident. That could be a bit tricky. We've then got the double tax treaty, though, for those who are not UK tax resident but who are working here. So if they are here only for a short period of time, it's possible that the starting position is under the tax treaty is that the individual could pay tax in the UK on the proportion of their income that is earned here. So that's where we talk about Section 690. So there's an agreement you go through with HMRC to agree a percentage. That they may not have to do that though. There are some provisions within the tax treaty, and the Malaysia double tax treaty is one of the relatively standard of that. It not be borne by the UK permanent establishment, because you're going to have a permanent establishment here, because you're going to have a place of being, a fixed residence here. So you're going to have that. So it can get quite tricky. So the individuals themselves are highly advised to actually get advice personally as well as the companies. It's a two-pronged thing. The other thing to say that if they are under the FIG regime, but they are being paid by the UK company, they may be able to qualify for something called overseas workday relief. That means that during that first 4 years, if they are working overseas and they're travelling overseas for part of it, so they go back to Malaysia and then they come back to or they're going to the US or something, they won't pay tax here in the UK on that element. So there's some fun calculations, and a lot of record keeping is needed. A lot of record keeping.
That's very complicated payroll wise.
Well, yes, it's interesting because you'll go down the section 690 route now. They change the rules slightly on that, but fundamentally what that does is you will agree a percentage with HMRC of how much work is being done in the UK and what's being done outside, and then the payroll kind of only applies to a percentage at that point.
Yeah, I think once that's set up, it's actually
easy.
quite easy.
Yeah, once it's set up, it's just getting there. So yeah. Are there any other points we need to think about in immigration?
Well, I have a question actually for both of you. So you raised there the possibility of the worker coming over from Malaysia, short period of time, maybe sticking within 183 days.
In that 12-month period.
And if they are remaining paid by the company in Malaysia, they're not going onto a former UK payroll, do they need a national insurance number at that point?
Not if they cannot be tax residents. If they're not tax resident and they're not paying anything and they're not going to be payrolled in the UK, I don't think so.
No.
See, that's quite useful when it comes to deciding what kind of visa people should apply for, because the standard skilled worker visa is the one where the national insurance number is applied for automatically as part of the process. But actually, if the intention is to retain their employment and payroll in home country, because they're only going to be coming over for, say, short periods like what you're talking about, falling within those thresholds, then actually that opens up a global business mobility route, which does allow for shorter trips. It doesn't require a physical presence, so you can have a longer visa, but they don't have to be here for the full period of time.
Interesting. I mean, they will still need to be very careful of statutory residency tests, because the 183 days is just what the double tax treaty requires. They could still find themselves tax resident here if they are here under certain conditions, if they become automatically resident because they're working full time here. That could be problematic, but I think that could be really useful if they're only going to be here for a short period of time. At least that makes life a little bit simpler.
I guess record keeping is key.
Record keeping is massive. So that's really important. Okay, right. Should we try the next scenario? What do we think?
So scenario 2 is a bit of a family scenario. So we have, in this instance, we have a US employee planning on moving to the UK in the middle of summer, so partway through the UK tax year, to marry somebody that's already living and working here in the UK. So they're a UK tax resident. They're going to continue working for their US employer. So from a payroll point of view here, this will be 100% a DPNI scheme. So, and that's as long as their US employer has no UK presence, either in the UK or any EU member state. So they will need to apply for a DPNI scheme. Now, this will fall onto the employer. The employee. The employee will need to apply for a DPNI scheme. The DPNI scheme will be in the name of the individual. And the responsibility falls onto that individual. So the way that this would work is they would apply to HMRC for this DPNI scheme. The DPNI scheme will be set up. Once it's set up, it will run in very much the same way a UK payroll will. However, there is no employer's national insurance due on this payroll because the employer has no UK presence.
15%, that's a pretty big thing.
Yeah, definitely. So each month, their US employer will pay them gross. So there's no deduction for Medicare, Social Security, anything like that. The individual will then declare how much to whether they're running the payroll themselves or someone like myself's running it. They'll say, hey, this is what hit my bank account today. We would then put that through the DPNI scheme and let them know how much tax and national insurance is due on that payment. So they will be responsible for paying that across to HMRC. There will be no mention really of their US employer on this DPNI scheme. I think when we set it up, we do need to just reference who they work for, what their duties are, and the location of their employer. But actually, yeah, there's no liability on the employer at all. In some cases, depending on what's in the employment contract, they may still have to register for a qualifying workplace pension scheme, but that's kind of case by case, and we'll be looking at the we'd have to look at the contract. So yeah, in this situation, 100% DPNI scheme.
Okay. What about an employer of record? I know that comes up sometimes.
Yeah, so in some cases, so they can use an employer of record. So this is where you would engage a third party who would legally employ the employee, and so they would deal with all the compliance themselves. Okay. Yeah, there would be no, but then, like we mentioned earlier, that's not technically their employer anymore. So that is another route. I don't see that often, if I'm honest. No.
Fair enough. Understand that. What about from an immigration point of view? What issues have we got with this guy coming to the UK?
Oh, well, when we see these we see these sorts of inquiries, and we get them quite a lot. All sorts of things are pinging off in your head of thinking, oh, well, it could be this, and oh, well, it could be that. The most important thing really is to understand the individual circumstances, both of the individual coming into the country, but then also the person they're intending to marry. The first thing most people will think about is, oh, it's a spouse visa. And most of the time it can be, but it's not always the best option. There are other aspects of the spouse categories which are quite complicated, including financial requirement. And where we're talking about they're not going to have a UK-based employer unless they use an EOR, then actually thinking about how that evidence of their earnings is going to be going forward. So not everybody qualifies for the spouse routes. And so you would have to have a look at, well, actually, what other visas will allow you to do what you want to do. It also depends on what the couple intend to do going forward, because a lot of the time people are, particularly post-COVID, much more mobile, especially around Europe. And I do get a lot of couples that say, actually, we want to travel around a bit. So they'll be having a look at things like nomad visas that exist around the globe.
A few times.
Yeah, and the UK, and a lot of people just think, especially from the US, there is an assumption that, oh, well, I'm not working for a UK company. I can work for an overseas company, and it's fine. It's not fine. It's still work. The UK doesn't have a remote worker visa scheme. It has the visitor rules, and what constitutes work under the visitor rules is a very, very, very fine line. And what you are and aren't allowed to do in that context is quite a careful assessment. So the first thing would be the timing. Yeah. When are you planning on coming over here? And what is it that you need to do when you get here? Because if the person is intending to arrive, work as normal, and then sort the visa out, that probably won't work.
Yeah,
so that's probably the first hurdle, really.
Okay, interesting, definitely. So again, lots and lots of things to think about before you even get here, and planning ahead of time.
Planning ahead is absolutely crucial.
Okay, fantastic. Okay, well, from a tax point of view, and I have seen this a few times, sadly, and it does tend to be people who are coming from the US because they will carry on working for the US employer. Because everybody's doing it since COVID. People work remotely. It's much more common than it used to be even 10 years ago.
Such a common scenario.
The problem is that we often find that the individual has decided to carry on working for their US employer and may not have told them that they are not going to be working in the US anymore. And they've just carried on paying US taxes and assumed that because they're paying US taxes, there's no UK tax to pay. And that is simply not the case. If you are a UK tax resident and you're physically sitting in the UK doing that work, then there is UK tax to pay. Again, and as an employee, DPNI scheme, it has to be reported under PAYE. Strictly it's need to be paid under PAYE. However, if there is no national insurance due, and sometimes there isn't, if you've got an agreement, you're going to carry on paying Social Security for a period of time in the US, you don't necessarily have to do it. You could report under self-assessment. However, you are still going to pay some UK income tax on that. If you are also paying US taxes, you are not necessarily going to get relief for that in the UK. You are probably going to have to go back to the US and ask them not to deduct it, or to do the adjustments there. In the UK, you are taxable here. We would get primary taxing rights on that sort of working because you are physically here in the UK.
Do you think their contract still comes into this as well? Because if they have an employment contract, I always think they need to be on a payroll or on a DPNI scheme. They're an employee.
Yeah, you can get around it if they're not needing to pay national insurance.
Okay.
You can on certain occasions. I would always go down the DPNI scheme. I think
it's so much cleaner.
Well, it's cleaner, and it's also if you're paying under self-assessment, you've got to worry about things like payments on account. You've then got to worry about saving the money. It's just easier for most people to manage their finances if it just pays it along. I think I prefer that anyway.
Absolutely, and I mean, if you want to go through anything like a mortgage application or any kind of finance, with the DPNI scheme, you're getting monthly pay slips. You can physically prove you're being paid. You get a P60 at the end of the year. I just think it's a far better.
It is far cleaner.
There's a benefit to, if they were thinking of the spouse routes, there's a massive benefit there as well. At the first application, the requirement for a spouse visa is very, very complicated, and there's lots and lots of different ways in which you can satisfy it. But generally speaking, if you're relying on earnings, there are salaried earnings that you can only rely on the British spouse's earnings for the first application when someone's entering the country. But for the extension, you can rely on both. So looking to your evidence from your DPNI scheme, you've got evidence for your financial requirement. If you haven't got evidence of your earnings, then it's very difficult to show how you would satisfy the financial requirement. It's all about evidence. You can have whatever earnings you say you have. If you haven't got the documentary evidence in a format that the Home Office is happy with, you can't use it.
I imagine they're quite strict as well.
Very strict. So evidence is really key, and it seems like the DPNI scheme would give them that.
I think so, especially since you're getting the evidence in real time as well, because the pay slip you're getting it once a month. Your self-assessment, you might not put that until months after the end of the tax year. So you are getting a severe lag on that. So interesting. Okay. The other thing that I think we need to cover off as well, and again, I'm not sure if it affects, it may affect the legal side of things, but coming during the summer, you are midway through a tax year. So from a tax perspective only, it's possible that depending on where you sit on the statutory residency test, which I've talked a lot more about on the previous event that we had. Again, we can share the video for that for anybody who would like that. But if you come to the UK midway through, then you may or may not qualify for something called split year treatment. Now, if you don't qualify for split year treatment and you tick all the boxes that make you tax resident for you, especially in the summer, because it's quite early in the tax year still, it's quite easy that you could become tax resident for a whole year, and you could end up paying taxes in the UK on the income that you had arising in the US before you even got here. Now, split year works in such a way as to stop that from happening. It allows you to be taxed from the date you got here. However, it's really notoriously difficult to claim split year because the conditions are quite difficult. Now, it's a little bit easier when you're coming to the UK than when you're leaving the UK, but for coming to the UK, you still need to be able to evidence you've started to work in the UK, or you've ceased working overseas, or you've ceased to have a home overseas. There are a lot of conditions that have to be go through and met. And there's no guarantee you'll get it. So you have to kind of think about that and work out whether or not you're going to end up paying. You won't pay double tax because there will be relief for tax you paid in the US. But the UK pays at a much higher rate generally because we have a lot less allowances than somewhere like the UK, or the US rather. There are a lot less deductibles. So you end up with, even if the tax rate was about the same, and they are about the same, you end up paying a bit more tax in the UK usually, which is annoying.
That's really interesting. And I didn't know that there was that implication because if we adjusted our scenario just a tiny bit and said that there's a child involved, moving into the country as well, and I won't go into that. I'm not going to go into that. The school year is a vital, and in nearly every inquiry I get a consideration. They want the children to school at the start of the school year, but then they're going to be hit by this midsummer issue, aren't they?
Potentially. So it's just it's worth, what I would say is get the advice before you come to the UK, take the tax advice, understand what you're going to do, and understand when you're going to become liable for tax. Because it is important to know that from the outset.
Most cases we come across at the moment, it's an afterthought, right? And trying to sort this out once you've been paying taxes in the US and you now owe a load of money to HMRC, it's not the easiest thing to sort out.
No, it's not easy. And then trying to get it back in the US as well. I mean, that's not us problem. That
No,
is
but I've heard
US
it's very
advisor, but
difficult.
it'd be quite,
Yeah.
But I don't want to give the money back.
No. But
No.
if you are physically doing the work here in the UK is not necessarily going to give you that relief. The relief has come with you actually. Is interesting. But yeah, I mean, before we move into scenario 3 though, the other kind of aspect we saw, I'm not going to go into great detail because we've had other webinars on this, but it's the IHT position. So that person who is now coming to the UK and has got a UK spouse, there are some interesting things around the IHT position because it could, if they're going to stay here long term, and hopefully if they're getting married to someone, this will get well, they're going to stay here, the kids will be brought up in the UK, and all that.
They've now got a child.
They've got a child. It's all of these things, exactly, all of these things. They may want to be in the UK long term. They suddenly going from someone who's not exposed to UK inheritance tax, and now they are. So if they're here for 10 years or more, and or if they've been in the UK before, and again that's covered a bit more in the bonus content we're coming around to later, they could be an IHT exposure, and that would, if they're here in the UK, then if they've got UK assets, they're going to be hit by UK inheritance tax when they pass away anyway. But if they've got overseas assets and they are here long term, so 10 years plus, that there is going to be a liability on those American assets, for example. Now, the American inheritance tax works very different. I mean, I'm not an expert on America in any way, shape, or form, but I know for a fact that they have IHT limits at like $15 million or something huge.
Wow.
In the UK, we don't have that. It's 325k, or maybe $1 million between you if you hit all the right kind of like conditions. So it's a big difference. So suddenly you've got to think about, I'm going to go and live in the UK. I'm going to end up paying inheritance tax when I die, potentially on my entire assets. And that is if you've been here for 10 years or more. And even if you have been here for 10 years or more, and then you leave, there is a tail. So you could get caught for another 10 years, potentially, depending on how long you are here. You could get caught for another 10 years for UK inheritance tax, even after you've left the UK on your overseas assets. So it's quite mean.
That doesn't seem fair.
It doesn't seem fair at all. You can talk to Rachel Breathed about that. You can talk to our Chancellor about that. And yes, these are the rules going in. So it's important to understand if you're coming to the UK, there are long-term UK tax things to think about.
I wonder, am I allowed to use the B word?
If you would like to.
Brexit.
Oh, okay.
Sorry, I did it.
Oh.
But you make me think about the hundreds of thousands of people that left the UK
So
as a result.
Yep.
And they were here, a lot of people were here for a very long time.
Rules changed recently. So there are transitional rules. These rules only really apply properly from the previous tax year, beginning of the previous tax year. So 2025, 26.
And it doesn't have retrospective effect.
No, not necessarily. You're under the old rules. So there were still old rules, and then there were some transitional rules. It's a little bit complicated, but it is effectively it's a lot longer now than it used to be. So if you got out before April 2025, so you were non-resident for 25, 26, you were probably caught by the old rules, not new rules.
Got it.
So yes, we did have a bit of flurry of people leaving the UK just before the rules changed, or also just as about the rules were about to be implemented. So good point there, very good point. Yes, you said B word. Okay. Anyway, so have we missed anything on any of those? Any other kind of points that you guys want to talk about that scenario?
I think there's only one thing that I would raise, but
Okay.
do you have something you thought was interesting as well?
Let's just have a look. Did I?
What was your point?
Yeah, I was like.
So I think I've said at the beginning when I was responding to what you mentioned about the DPNI schemes was that the first thing was the flagging of spouse visas, but it's not the be all and end all. And actually, again, it's always a good idea to have a look at individual eligibility for other routes. There are so many visa routes that allow someone to work if the circumstances are there, if the criteria are there. And if the couple isn't intending to stay in the UK long term, perhaps maybe because of some of the things you've talked about, then actually some of the shorter visas, like a high potential individual or whatever, they can work very well as well. So I think it's plan early, but consider all of the options to make a fully informed decision, whether it's a short-term goal you want or a long-term goal.
Yeah, okay. Yeah, I know exactly. It goes back to what we were saying in the original scenario, again, about the FIG regime. If you're only going to be here for 4 years and you've not been in the UK before, it could be very beneficial to be in the UK because you're not going to pay tax on your overseas income gains. But long term, we've got to think about it. So I think having a plan before you come is key, definitely, and understanding what the rules are. Okay, so we're going to look at our third and final scenario. So we've got to move to Europe at this point to kind of like, so you can see some of the Europeans. So admittedly, a lot of the people I see in this scenario are not necessarily coming back from Europe. They're coming back from the UAE because apparently it's a lot less attractive than it used to be. But for our purpose of our scenario, we're going to be talking about France. So we have an individual, a French individual, who's been living and working in France for a period of time, but they now want to come back to the UK, having been here previously. And they're going to be working for their French employer, which doesn't have a UK branch or anything. So they're going to work remotely, like our American gentleman did. But leaving the UK, before they left the UK first time around, they had settled status. So they have been in the UK historically. Now, as I said before, we have got some bonus content about the tax side of this coming around later, because there are a lot of things to cover on the tax, and I'm only going to skim across it to a certain extent, because you've got the bonus material coming around, and what's actually more interesting is what these two are going to do. So from my point of view, from a tax point of view, though, temporary non-residents is the main thing to think about. They've been away from the UK, but it depends how long they've been away. Well, we've deliberately kept it fairly loose, so again, we can cover all the scenarios here. But if they have been outside of the UK for less than 5 years, and I would usually go 5 tax years to be absolutely certain on this, if they've been outside of the UK, they could be affected by something called temporary non-residency. Now, what that means is if you come back to you've been in the UK for 4 out of 7 years prior to going, you leave and then you come back, there are certain things that would not have attracted UK tax during that period of absence. If you come back too soon, though, that can come back and charge and be taxable in the year you return to the UK. So it affects things like dividends from closed companies, flexible pension drawdowns, all of these kind of capital gains is the big one. Capital gains on assets that you owned before you left the UK, that you sold while you were gone. So that's an important one for people who are thinking about selling businesses, and we've seen that a lot, and again covered a lot more in detail in the previous presentation. So that has to be thought about. You have then got split year treatment issues as well, because again, if you're not gone for long enough, you may not meet the conditions to qualify for split year. You're thinking about tax or getting advice about what to do on that. There's also, there are other ways to look at it. We often get asked by people who are coming to the UK to work for an overseas company who doesn't have somebody here, especially from Europe, is whether or not they can structure their employment as consultancy income. Now, this is a really interesting one because again, there are legal, there are payroll, there are tax implications of all of this, and we often get asked to compare. Well, what would it be like if I consult for my French employer rather than I'm on a payroll, for example? And I guess it comes down to what does your contract say?
Exactly.
And that's where it all comes in, and where it all potentially falls down. If your contract says that you're an employee of that company, we're going to tax you as an employee in this country.
And you're treated as an employee.
Absolutely.
You get everything that an employee gets. You're an employee.
You're an employee. Okay, so how's that going to work?
So this would be very similar to scenario one. We mentioned earlier on, so presence either in the UK, so you cannot register for a DPNI scheme if your employer has presence in either the UK or any EU member state. So obviously, France is an EU member state, so they would be required to operate a UK payroll, a qualifying UK pension scheme, and yeah, exactly the same situation as scenario one, really. Employers don't necessarily like this advice because it's not an ideal situation for them, but HMRC would require them to do this.
And it is the responsibility, of course, of the employer, not the employee at that point. And what about national insurance? I'm guessing that's got to be.
So we're in the same. So there'll be the employee will be added to a UK payroll. There will be employee tax and national insurance due, and the French employer would be required to pay UK employers' national insurance.
Presumably, though, they may qualify for some sort of exemption, in which case then they would get a full A1 or something like that.
Dependent on, I mean, each case is different.
Each case is different.
Each case is different.
But potentially very expensive in terms of the national insurance.
Definitely. So yeah, another UK POA scheme on this one.
Okay. That's what it is. Unfortunately, the employer has to do that. But of course, from the immigration point of view, we've left this deliberately open so you can have because I know this one's interesting.
Well, you have mentioned 2 key periods there.
Yeah.
Because you mentioned about 18 months and you also mentioned about 5 years.
Yeah.
So settled status, when I hear that, I hear settled status under the EU settlement scheme.
Okay.
So European national or related family member who acquired settled status, so i.e. permanent residence, before they left. And it could also mean indefinite leave to remain. All sounds like the same thing, but actually it's quite different, because indefinite leave to remain falls under the immigration rules, always has, but settled status is a very specific type of permanent residence that was deliberately created post-Brexit. Oh, I said it again. One webinar, sorry about that. The reason it's so significant is because if you have indefinite leave to remain, 2 years absence can result in your ILR being rescinded.
That's me.
Yeah.
Wow.
Whereas settled status, it's 5 years.
Ah, okay.
So those dates that you were talking about actually are really crucial.
Okay.
And if somebody is looking to return and they have been outside of the country for exceeding the relevant 2 or 5 year period, then my strong advice is do all your planning and so on and so forth, but actually don't just rock up at the border.
Yeah.
Because there's a risk there that the border official, you know, if you have to see a border official, they might ask the question of, well, I can see from the records, because they can see when people come in and come out, you know, and we're getting more and more tech within the immigration system, more and more automation across different government departments. They can see you haven't been in the country for X period of time. Actually, no, I'm not going to enter you as ILR. I'm going to enter you as a visitor.
Oh, God. And then what happens?
Can't work.
Oh, no. Oh, gosh. Okay.
And I'm not going to go into another rabbit hole how you deal with that situation. You can deal with it, but it depends very much on the circumstances. The best thing to do really is, if you have exceeded the required periods, is returning resident visa.
Okay.
And in that, you have to evidence the ties that you have maintained and still maintain in the UK. And you mentioned about assets sold.
Yeah.
Now, if they haven't sold those assets, that's probably a good thing, because it forms part of the ties that they've maintained in the country. If they sell everything and it's, you know, a scorched the earth sort of situation, then that returning resident visa is going to be a little more tricky to basically convince the Home Office to reinstate their permanent status. And if the Home Office refuses to do that, then they're back to square one.
What do you do in that situation? You're there, you've been turned away.
You're at the airport.
You're at the airport, you're waiting to go. What do you do in that
Well, there is
situation?
a risk of being turned away, but generally I would say that the border official is more likely to enter you as a visitor.
Okay.
And then you deal with it separately. But it's a stressful situation to be in. The reality of it happening, the probability, I should say, of it happening to a French national or a European national, because we have the e-gates already, is probably fairly slim.
Okay.
They're probably just going to go straight through the border, but that presents a different legal problem, which we probably don't have time for today. Well, yes and no. It's a bit of a grey area. That's why, it's very tricky to sort of reconcile it, because then, well, actually, what is your status? Do you see what I mean?
Yeah.
It's a very intricate legal question. But with the e-gates, we know that they're not foolproof.
No.
So when we're looking at these sorts of situations, we're always advising clients, be prepared. If you have to see a border official, how will you deal with that? They have a great deal of discretion of what they can and can't ask you and what they can and can't do.
I didn't know they had that power.
They have a lot of power. until you're past the border, you are in basically borderland, and that's a bit. Even I get a bit, you know,
because you know what they can do.
Yeah.
That excites me as well. Wow.
I think the other thing to remember is that if you've got your returning resident visa, you've reinstated your ILR or your settled status, happy days. But then actually, what's your long-term goal? You've come back to the UK after a period of absence. There's a reason for that. What's the reason? Is it because this is now the permanent home? Because that's the basis of returning resident anyway.
It's not the weather, is it?
Well, I don't know. This week's not doing too badly.
Doing all right.
But generally speaking, it's because people want to return here on a permanent basis. So they're usually thinking about what's beyond that. Citizenship.
Yeah.
So naturalisation, getting a British passport. But because they've been outside the UK for such a long time, they won't meet the residency requirements for citizenship. And it's going to take them a lot longer to be able to satisfy that criteria. Sometimes it could be as long as 5 to 6 years. So that's something else for them to bear in mind in terms of the long-term goals.
Of course, and if they are coming back, the chances are, again, from a tax perspective, is they probably, if they've been here at some point during the last 10 years, they're not going to get the FIG regime. So they're instantly going to be paying tax on their worldwide income again. So if they've got stuff going on in France, going to pay tax on it. So if you've got investments or leaving your French property and it's going to be rented out, that will be taxed every year. So again, it's that length of time. If you've been gone a long time, you may still qualify for the FIG. So if you said 10 years, but if you haven't, so there's all untold problems. I think coming back to the UK, as I say, it is probably the more complicated scenario for most people to think about, I suspect.
And yet the one that's probably most overlooked.
Yeah. It's been here before we know it.
It's been here before.
But there are changes. There are changes in certainly in the tax legislation. DPNI, I mean, you used to be able to get a French DPNI through. We used to get them through occasionally, but they really have cut
It was
down.
a grey. It used
a
to be
grey
a
area.
grey area. It's not anymore at all.
Not anymore.
No.
I had a question actually about that. So when you were talking about a company that would have to, they're an employee, they'd have to set up payroll, have to set up the systems to get national insurance. What if they don't have a company or an organisation registered in the UK? Can they do that with a foreign registered company? Or do they have to then register an overseas branch of company's house?
No. So you can absolutely register a UK payroll with a director that doesn't have a national insurance number. You just have to do it over the phone.
Okay.
So you just have some patience.
You've got back jobs.
And make sure you're calling at 8 a.m. in the morning. But apart from that, yeah, they'll absolutely let you register.
So because I've got an active inquiry. I've got an active inquiry very similar to this one at the moment. So in the scenario where you've got the French company and they want to, and this person's coming into the UK for their reasons, and they've got no plans to set up any kind of presence here whatsoever. There's no company being registered. There's no offices, no nothing. That can
This is
still
why it
work.
seems unfair. This is why employers in like EU member states outside of the UK they hate this, because it's like, well, we're not in the UK. Why should we have to pay? Yeah, but unfortunately
They can still do it.
they're the rules. Yeah.
Interesting.
Oh dear. Okay. Well, funny.
And actually, the fact that they then have to register for a pension and pay into a pension, and it's just
a lot of paperwork.
it is a lot of paperwork.
Not cheap, unfortunately.
But the thing is, if you've employed somebody that's here in the UK, you've told them that they continue it, you generally want to keep them, right?
Absolutely, of course. You're going to be flexible about the staff you want to keep.
Yeah.
Absolutely understand.
Definitely.
Although I have known employers who have refused to allow people certainly to go to other countries, and it's interesting.
I mean, that's another rabbit hole, probably for a whole webinar.
Okay, thanks.
The first question is, with UK labour costs, there is much appetite for hiring offshore talent on a subcontractual basis. Are there UK or overseas liability risks?
Right, where do you want to start with that? We've got subbies here in the UK. Is that what we're saying?
Yeah, I'm just thinking the question. Can you just read it out one more time? Sorry.
With UK labour costs, there is much appetite for hiring offshore talent on a subcontractual basis.
Right.
Are there UK or overseas liability risks?
I see what you're saying. So we have got individuals who are overseas who are having to deal with the working.
So it's like the other way around.
Other way around. Okay, interesting. I mean, from a tax point of view, it's going to come down to where the individual is. So each individual, we need to look at if they're in Romania, for example, then they're going to have to get Romanian advice, certainly from a tax point of view, I think.
Definitely, because even when it comes down to tax code, pension on the payroll, things like that, they're not in the UK.
They're not in the UK, no. So it will be unusual for them to be taxed in the UK. It's slightly different with directors, I think. So if you've got an overseas director, we do have to think a little bit more carefully about it. But for a straightforward subcontracted employer, I'm not particularly worried from a UK perspective. What about legal?
No, UK immigration is based about physical presence. So if they're not in the UK, we're not worried.
I think it's the same across all three. You're not here in the UK.
You're not here in the UK. It's somebody else's problem at that point.
Yeah.
Thanks, David.
Okay, I am a freelance translator and interpreter now living in the UK and thus paying UK tax. I have an NI number. I continue to work for Europe-based clients who pay me in euros. The question is, should I open a euro account with my UK bank?
Fair point. I mean, it's a practical question rather than a tax question. I don't think there's too much in the way of legal. I'll let you answer that in a minute. But I think I'm from a tax perspective, I'm very relaxed. If it makes it easier for you to have an overseas bank account, then absolutely, it's not going to change your UK tax position.
Yeah, agree. The only issue I've got here is asking if you're working for European companies, are you going to fall within some of the things we've talked about today with your own right to work in the country? So I would just ask I would ask a further question back and ask the person if they are British or already have a visa in their own right, to allow them to work in the UK. If they do, then there's no issues from our side on what bank account they have.
And you'll
And from a payroll point of view, they're a freelancer.
Yeah.
They're not on a payroll. So yeah.
Fair enough. But of course, as a freelancer, there are lots of other issues you need to think about, which are outside the scope of what we're going to talk about. But I would highly recommend tuning in for the doing business in the UK, because that may be more relevant. So, for example, from a VAT perspective, I mean, again, not a VAT person, not going to stray into that. But I think if you're a freelancer rather than an employee, there are other issues to consider that need to be thought about.
Is an overseas entity, e.g. GmbH incorporated and established in Germany, required to have employers' liability insurance in place where it will be sending its employees to the UK to work on a construction project? For the avoidance of doubt, the overseas entity does not have a place of business in the UK, is using employees not ordinarily resident in Great Britain to undertake construction work, and is not required to operate PAYE, deduct income tax or national insurance.
My word, that's specific. I think that's going to come down to doing business in the UK. That is definitely, we are kind of looking very much from the kind of individual point of view today. I think if you are a company, an overseas company sending people to work here, you will definitely benefit from logging in on the, what did we say, it was 23rd of September to have a chat. It's outside of my remit. So do you know that? Oh, you don't really know.
I think that's an insurance law question.
Yeah, possibly an insurance law question.
Yeah.
Which we are not insurance lawyers. I'm very sorry about that. We cannot help on this particular occasion.
I'd love to dive into the visa situation on that though. That wasn't what the question was.
I would question though why they're not required to run a UK PAYE scheme, because they're in Germany, EU member state.
With people here.
With people here, yeah.
Interesting. Yes. Okay. So if you want to have a chat about that, who have sent that question in, please do get in contact either with Gravity or Taylor Rose, and we will be quite happy to kind of assist on a bit more of a deeper level on that one. That's it. Okay. Fantastic. All right. So we don't have any more questions. So again, thank you all so much for joining us. There will be, as I say, you'll get a pack come around over the next few days with the highlights, edited highlights sort of slides. From the three of us with our contact details on, so you'll have all the Taylor Rose's details, all the Gravitas details, with the headlines from what we've been discussing today. There will also be bonus content with Tom Adcock, which is about coming back to the UK, doing a proper deep dive into the tax perspective on that. And then if you could answer any feedback, if you've got the polls and you want any feedback, that'd be lovely. Please do reach out if there are any further questions. We are always happy to help. And thank you very much for joining and for staying for the whole 50 minutes. Enjoy yourselves. Take care.
Thank you.
Thank
you. Bye.